Thank you, Mr. Chair. Um, you're doing really great. We've had a lot of questions for you today. I am going to go back on some of the stuff that you've been asked. When this is over, we have to do some deliberation. I want to make sure that I'm clear on what you are telling us. Some of it is because you've gone back and forth with different folks, has gotten a little muddled in my mind. So I'm going to start off with a question related to what a representative was asking you earlier about justice, and your answer was like the answer you gave me when we met, very much about procedure and things of that nature. And then you ended off saying, but we're making progress. And I guess my question is about that because I'm known to be a fan of James Baldwin, and one of the things that Baldwin talked about was, or asked in the public forum, was how much time must be given for progress because his mother, his father, his uncle's time had been eaten up. And your answer falls, whether you mean to or not, seems to fall in line with that question. It's a question he had. It's a question I have. What is your understanding of what justice is? And I will tell you, surprisingly, a lot of folks who have sat there, whether it be for the Superior Court or one of the other courts, Supreme Court, have failed on this question. So I'm interested in you clarifying for me what you perceive it to be and what it has to do with what you do.
So to me, I see our justice system, both the civil and the criminal justice system, as being part of our social compact. You know, we agree to be bound by laws as written for the common good. And there are breaches of those compacts. And when people breach those, we have a justice system to help repair that breach. It's not going to solve all the problems, and it's not going to repair it completely. But we have a system that provides a way to provide a piece of that. And so it's procedural, yes, and I think that's crucial. I think it is foundational. But it's not just procedural. It is also a substantive outcome in the sense that it has to take into account all of the stakeholders in that system, because it is about the person who has offended the social compact, has offended the laws, but it's also about the community who feels less safe because there was a murder in their midst, or there was a shooting in their midst, or because there was somebody swindling their grandmother out of money. You know, that community safety is something we have to take into account. But justice also involves taking into account the interest of victims, and somebody who has lost money to someone who swindled them, or someone who has lost a loved one to a shooting, or suffered at the hands of other violent conduct. And so to me, but when you also circle back to the offender, also understanding that the justice system isn't going to solve all of the problems that led somebody to that breach, whatever it was. Often, one of the things that I do in my job is read a lot of the pre-sentence reports. So when somebody is ready for sentencing, the probation office prepares a pre-sentence report that goes through a detailed history of this person's life and how they got to this point. And those are often really tragic. And it is rare that sending someone to prison is going to actually solve any of those problems. Maybe it will. So it may not the problems that come from that. But our justice system serves all kinds of purposes, and part of it is balancing those interests and finding a way to provide some measure of maybe incapacitation, maybe redress to the victims, ensuring a victim gets restitution, maybe understanding the seriousness of the offense conduct, the impact on the community. Those are all factors that I think are important to take into account in a justice system. But I also, I think it's also important to recognize that I think a justice system has to be aware that it can't solve all those problems, and that understanding that when people come out of prison, because almost everybody's coming out of prison, if we're talking about a prison sentence, they're going to be part of our community again. And so what are we doing about ensuring that the community can heal? And sometimes the justice system can't do anything about that. Sometimes we can, and have we done what we can within the authorities that we have? Or are we referring people to the right sources to get help with those problems that the justice system can't solve?
Thank you. And I don't know that you feel this, but and maybe I shouldn't say this, but it feels like, and I get why that's a hot seat to be in, but it feels like you're trying to answer my question, and I'm just trying to figure out how you think. So your answer is what it is. It's correct in and of itself because it is your answer. And I also want to say that I'm not just thinking about what we traditionally talk about as the criminal justice system. I'm thinking about questions like Representative Johnson's questions about the LGBTQ community. I'm thinking about questions about some of the things that have happened in our history, because you very much seem to think that the rule of law is important, and it is. But the rule of law is also sometimes the way in which we have some very nasty things happen in our country. There was a conversation earlier about Plessy. When you take Dred Scott case, Plessy, and the Cummings case, the Board of Education case, a couple of years after Plessy, the rule of law would tell you that people like myself should not necessarily get what we now get out of these systems. And so I guess if you could talk to me a little bit about understanding that the rule of law is important, but that the rule of law itself, given who has dictated what the rule of law is, can very much be part of the problem as well. It might help me to understand your perspective better.
No, I think that's a really fair point, and something that I've thought about a lot over the last, 6 or 7 years. And let me give you an example, and I'll try to not say anything out of turn. In the prior administration, there was a policy adopted at the border of separating children from their families. And in a strict reading of the law, on one level, there was authorization for that policy. It was monstrous. And it's the kind of policy that, some good people objected to within the government, but not enough. That kind of, using the law to bad ends is something that I think we all have to be attuned to. Am I being asked to do something that, in its impact is monstrous or is bad, or as a substantive matter shouldn't exist? And those are questions that I think any justice system needs to continue to ask, and be open to hearing criticisms of the system, and be open to hearing, here's where we think you can do better, here's where you think the law is being used to harm people or individuals or communities. And I think any justice system needs to be open to hearing those criticisms.
Thank you. And we're gonna walk into the letter, but just before we get there, in response to those who've asked you questions today, you talked about the guardrails, and I guess I want to understand your thinking about these guardrails. We just talked about how the rule of law can sometimes lead us to a space we never should have been in, and that's not just a sin of presentism, that's just we should never have been there. When I think also about cases beyond the ones that I mentioned, when I think about Korematsu, when I think about Minor versus Happersett, when I think about, we could probably all go and list a number of cases. What I see is that human beings have issues and they're flawed. And ever since around the 14th century, when the notion of stare decisis came in, there's always been an out for it, which is bad law, which is interpreted by human beings. Given what we've done in terms of cases here in the United States of America, given the frailty of human beings, and given that loophole, the notion that guardrails were going to protect us, and maybe this is because I come from one of the communities of folks who the system has not worked for largely. The notion that guardrails would protect us, to me, just doesn't make a lot of sense, I guess. I was going to try to find a better way to put that, but it doesn't make a lot of sense. So I think people like myself would not necessarily believe that there were guardrails and would be hyper vigilant. Can you talk to me about your notion of guardrails and why you thought they would protect us?
My notion of guardrails was that courts were bound by prior decisions, that courts were bound by the decisions of the Supreme Court and couldn't take actions. And I think you're exactly right, Senator Winfield. I think my impression that guardrails would protect us reflects my experience with the criminal justice system and with the law more generally, that is probably not reflected by your practice. And probably you were probably more attuned to the dangers than I was. I admit to being naive and not seeing that danger and not understanding how the system sometimes doesn't work for communities, for certain people, and maybe that I'm in part of the community that it has historically worked for, and so I don't see the problems. And that's something that I have known. That's something that I've learned over the years. And so I see that as a clearly a blind spot that I had. But I just telling you where I was at the time and understanding what I know now, I had too much faith in those guardrails and thought that they were really working in a system that they clearly weren't.
And when we talked about Plessy ultimately changed because we have Brown versus the Board of Ed. As it relates to the conversation around the letter, Brown versus the Board of Ed is perhaps the jumping off point, which leads us into the whole conversation for political reasons around Roe versus Wade and the peppering, if you will, of the federal judiciary for the last 40 plus years. That context existed prior to 2016. You said you went to Washington and you were concerned, and yet you did sign on the letter. I guess, as someone who has expressed that you wanted to be a judge in the federal system, are you unaware of what was going on in the system for the last 40 years of seating judges in order to get them to the Supreme? Absent Amy Coney Barrett, right? Absent her for a second, were you not clued into that? Oh, I don't mean to be pejorative in the question. I just want to know, were you aware, or was it something you were aware of but not paying attention to? What is the case there?
I think I was part of a legal culture that saw the ability to work with people who you disagreed with that was just part of what was part about doing law. I think I was naive and didn't understand the full extent or how fast or how hard our institutions would fall. I believed, our courts did some really good things, but they didn't do all the good things, and they didn't do enough. But, do I wish I hadn't signed it? Would I do it again? No,
And I appreciate that. You in the meeting with myself and my co-chair, drew a distinction between the appellate court and the Supreme Court, and there is a distinction. I pushed back and said that the appellate court, kind of like what I just talked about with the peppering, the appellate court is how we get things to the Supreme Court. And I think that's why my emails have been full of people who are concerned about a vote in the positive for you. When you talked about the letter, you talked about it as if, we didn't agree with Amy Coney Barrett, but what the letter says at the end is that she's fully qualified and would be an excellent addition. I don't know how someone walks away understanding that you are putting her forward as anything other than somebody who's in the federal system, as somebody who likely is aware of what's going on, who says that this person, from their perspective, if you're a signee, thinks whatever opinion she holds is okay enough for her to be on that bench, which would actually be helping to send cases to the Supreme Court, having been judged a certain way. And that, to me, is concerning. It really is. But we've talked about that a lot. What we haven't talked about is, excuse me, in 2017 when this was going on, there were a lot of folks talking about Amy Coney Barrett. And those of us who are news nerds like myself were paying attention. People who are in the federal system were paying attention. And I haven't heard from you till today, including the meeting we had the other day, at least not as strong as you did today, that you said, I can't stand by some of the statements that were in the letter. So I would ask you, first, what do you mean by that? What statements can't you stand by? And I'd ask you, I get the culture thing, but this is a person who you hadn't, well, actually, you said to say that you worked together was a misnomer. And I get that, right? You were maybe proximate, but you weren't really working together. This is a person who you also hadn't seen in almost 20 years. Could you just, maybe I'm asking the same question. I'll just stop there and let you answer.
So this letter that was signed by everybody who clerked that year, including the clerks for the most liberal justices, reflected our experience with her in 1998 and 1999. Based on my observations of her over the last 6 years and her voting record, I can't stand by characterizations in the record that she's honorable and fair-minded, or that she has respect for the law. I don't see signing on to Dobbs as someone having respect for the law. And, I'll stop there.
Okay. I don't want to spend a lot more time on that. We've been here a lot today, and I think it's close to time for you to have some relief. I do want to touch on the issue of you sitting here. So I believe you have expressed both when we met before and today that you did have interest in becoming a federal judge. But what I walk away with, and I want to make sure I walk away with the correct impression, is that you weren't interested enough to pursue being a state judge and of some sort. Whether it be a justice of the Supreme Court or a judge of the Superior Court or whatever the case may be. There's been a lot of conversation about folks who've been on the list and the way these things work, and the qualifications have been a part of this conversation. And as someone who sat on this committee for a very long time, for me, it is often difficult when someone gets through the system as quickly as you did. We've had people who, several of us have tried to figure out why we can't get them even through judicial selection. Um, why do you want to? Why do you want to be here now? It didn't seem that you wanted to be here before being asked.
I love what I do. I love my job. I have been able to combine my love for the law with a commitment to public service. And while it was true that at various times I've thought about other ways to contribute to the public, the state court bench was really just not something that was on my radar screen or seemed like something that would match my skill set with my ability to serve at a particular time. And so, when I was contacted and asked if I was interested in being considered, I spent some time thinking about it and talking to my family and thinking about what it would mean and whether I felt like I could do the job, whether I could contribute to the people of Connecticut in that way. And I ultimately came to the conclusion that I could, and that this would be a way that I could serve the people of Connecticut and contribute my legal skills to what I consider to be a vital part of our state government, a strong and independent judiciary.
Earlier you spoke about humility being a part of who you are. Recently, in addition to the question, at least for the Superior Court judges, on robitis, where humility tends to come up, I've asked additionally, what are people's systems of accountability? And I know it's a little different between the Superior Court and the Supreme Court in terms of interactions and all of that, but I think the question of systems of accountability still remains an important question. What are your systems of accountability?
Well, as I mentioned earlier, I think one of the core systems, aside from my personality, is that I would ask my colleagues to hold me accountable for my conduct and for making sure that I am treating people with dignity and respect always. I think that the Connecticut Supreme Court is somewhat unique in that all of its, or most of its hearings are broadcast and saved, so, temperament can be observed by outside observers. I think that's a really good thing for any court system. And so I think those are two systems. One of the things that I worked for two judges who were both in different ways really singular legal figures. Judge Posner is a eminent legal scholar, and Justice O'Connor was the first woman and served for many, many years. Both of them showed me how to be a judge who is humble and aware of their role, that their role is to be a public servant. And one of the things that Judge Posner did, and I think I've mentioned it here, although I may have lost track at this point, that he was really open to criticism. And one of the things that he did was he had us call him Dick. His name is Richard Posner, and his clerks were to call him Dick, which is not something that a lot of judges do. Most judges have you call them Judge Posner or Justice O'Connor. But he thought it was important because he knew that when he put on the robe and became Judge Posner, that put up a little bit of separation, and that put up a little bit of people being afraid to tell him what they thought or being afraid to challenge him. And I think that part of being robitis, one of the problems with robitis, aside from treating people poorly in a courtroom and treating people without dignity and respect, is that you then aren't hearing the people around you. You're not hearing contrary views. You're not hearing facts that challenge your worldview. You're not hearing from outside perspectives. And so I think about that a lot, and how do I take that and translate that for me into a day-to-day work environment that allows everybody around me to feel like they can come to me with concerns or questions that challenges to the way I'm approaching a case.
I appreciate that. I would just comment to say that I hope, and I think this is what you mean, that when you say your colleagues, you don't just mean the other justices, you mean all of the folks around you working in that system. And I would just encourage you. I think many of us, first of all, we're always televised, and depending on the day, it's not a side of the aisle thing. People have opinions about how we operate, so I don't know that televised necessarily does it, but I get your point. But I would encourage you to not just think of allowing people to call you by your name or something of that nature, but really think of ways in which what you are suggesting to those people, they feel empowered to do. Because I have observed that many people will go and think they are setting these things up, but people do not feel empowered to actually, when it matters, say what's necessary. So with that, I think we've been here long enough. I will just say this. This is an important decision we make, and I really wish that I almost wish the letter hadn't ever showed up and that we still had a hearing like this. Oftentimes, people come here to be a judge of any of our courts, and the hearings feel, at least, I'm not going to suggest that they are, but they feel as though they just go by too quickly. They feel as though it's a done deal before someone moves forward to sit on, whether it be the Superior Court, Appellate Court, or the Supreme Court. I hear from the public oftentimes that they don't feel like we've done our due diligence. I think that letter is a reminder that we need to do our due diligence. I'm sure it's also a reminder to you that you need to do your due diligence. With that, I thank you for joining us today.
Thank you.
Thank you, Senator.